Ethics and the law. Going to touch upon the problem that we've been seeing over the last decade of lawyers behaving badly when it comes to electronic discovery. There's been more sanction cases against attorneys and indeed entire law firms related to electronic discovery in the past 10 years than I can ever remember. I mean, there's never been anything like this. The reasons for this is something I've given a lot of thought to. I think a lot of it has to do with the fact that most attorneys are not comfortable with the technology involved, and they're not really sure what to do. And when you're not really sure what to do, lawyers tend to err on the side of being over-aggressive, maybe going too far to protect their clients. They think they're protecting their clients. Actually, they're inviting them to join them in sanctions. Now, we see several different kinds of sanctions in the world of electronic discovery. Typically, they relate to hide-the-ball activities of not fulfilling their duty to comply with the rules and to produce evidence fairly squarely requested, clearly relevant, not privileged. They're still not producing it because it's going to harm their client. Well, that's fundamental, that you have to produce information fairly squarely requested, regardless of whether it harms your client. That's just basic duty of candor to the court, duty of fairness to opposing counsel, required by rules of procedure, all state rules and federal rules. Federal rules required under Rule 26G. Not to do that is, to use a legal term, fraud. It's deception. It's dishonest. It's obviously unethical. And yet it keeps happening time and time again. This is something that the courts are really fed up with. Some courts are pretty notorious that if they hear about a party actually hiding or destroying evidence, I've seen them stop a trial right in the middle of a trial and say, we're going to adjourn the whole thing, and immediately refer it to the United States Attorney for investigation. Yeah, judges take the destruction of evidence very seriously, as they should. It can come from hiding the ball. It can also come from not saving the ball at all. I mean, you don't hide it if you don't tell the client not to delete it, or if the client deletes it and you wink and a nod, you don't do anything to stop them. And that's why all firms today send out written notices reminding the client of their duty to preserve. And they should do the next step too, which is to follow up with the client. Make sure they understood your reminders. Make sure they complied with it. How did they comply with it? Assist them in the compliance. If you're counsel of record, you have a duty to the court, duty to your client, both, to make sure that they comply with the rules, to make sure that the evidence is preserved. So that's one of the things we see, cases where the client doesn't preserve and the lawyer either is absent, or worst case scenario for our profession, the lawyer is complicit in the client's activities. So it's very important that you make sure that the evidence is preserved from the get-go. Another area that we see sanctions in all too often of clients and attorneys is where the evidence is preserved. They haven't allowed it to be deleted. They haven't allowed the automatic deletion that goes on in many companies. Perfectly nothing wrong with that, unless and until there's a lawsuit. The minute there's a lawsuit, well, there's a duty to preserve that's triggered. It's contemporaneous, really, with the work product. It's early. For a plaintiff, it's before suit is filed. It's when they've decided, well, we're going to file suit. When that happens, Mr. or Mrs. Plaintiff, you got a duty to preserve. Attorneys for plaintiff, you've got a duty to preserve. This is critical and clear, well established in the case law. And it's unethical not to preserve the evidence, good or bad. Particularly the evidence that's not good for you. It's easy to preserve the evidence that's good for you. There's no ethical conundrum there. What's hard is to preserve the evidence that's not good for you. And that's where the ethics comes in, and that's where it's critical that you make sure it's saved. In addition to that, though, even if it's saved, you got to find it. I mean, it could be hidden in plain view. It could be a haystack, needle in the haystack. So you got to find it. You need to use reasonable efforts to find it. Rule 26G in the federal arena requires that there be reasonable efforts put forth to get it. So you can't just, do one keyword search and that's it. Wasn't there? Oh, that's it. Got it all. Just stick with what I got. No, you have to do a thorough search. Just like in the paper days, you had to do a thorough search through the paper files. Same thing with the electronic files. Yeah, maybe a little more difficult, but that's why you have skilled specialists in electronic discovery where it's not difficult. That's what they do. So you need to put forth the effort to find the information. Then, and this is, sometimes it's just that you don't know any better, in which case should you be doing something you don't know how to do? A lot of state bar associations now are making clear that attorneys have a duty of technical competence. You need to be competent. You need to know how to find the evidence in your client's computers. It's not easy sometimes when your client has thousands, tens of thousands of computers, very complicated cloud storage systems. I mean, it can get very difficult. So you need to get help with that. Vendors can help you. Other attorneys that specialize in this can help you. But if you're not competent in doing it, you can't just do, pardon my French, you can't do a half-assed job and expect that to cut mustard. No, you need to make a reasonable effort. And what's reasonable, it depends on the circumstances. Depends on proportionality, too. What's reasonable in a $100 million case is way overkill and not required in a $100,000 case. So that's what reasonability is. It entails proportionality. So you have to make reasonable efforts to preserve, reasonable efforts to search, and then you have to be honest and reasonable in actually making the production. I don't know why it is that some attorneys think because it's a computer file, it's not really evidence and it's okay to delete it. It's not okay. Yeah, it may just be electronic. It may be, the word is ephemeral. It has no material existence. It's just an electronic collection of pluses and minuses, but it creates a document and it's as real and it's as evidence as paper. It is evidence. So when you come across a damning to your client piece of evidence, and again, assuming it's fairly requested, no question it's relevant, not privileged, you got to produce it. There's no thinking about it. You have to produce it. Not to produce it is fraud. Not to produce it is dishonest. Not to produce it is unethical. So hiding the ball is not okay. It's not a good, sharp practice for vigorous advocacy. Not at all. It's just plain fraud. Can't be done. So train yourself with that and realize that sometimes the information you find when you're doing an electronic document review is going to be great, good. Sometimes it's going to be bad. It's going to be terrible. You may find your client was lying to you. Happens. You may find that a key witness was not telling the truth because the documents written at the time, the contemporaneous writings impeach that client. I mean, worst case scenario, you may come across a document where your whole case is blown out the window. Of course you don't want to produce it. Of course your client doesn't want you to produce it. Well, you have to. Either that or you have to, if you're a plaintiff, dismiss the case, suffer the consequences. Defendant, pay the judgment, suffer the consequences. There's just no gray area about this. There is no exception to, the rule of production and the rules of procedure and the rules of fairness just because it's not going to help your client. Somehow or other, some attorneys don't get this. They seem to think that their job as an advocate is to manufacture evidence, to control evidence, to mold evidence. It's not. It's to make the best case possible with the evidence you have. It's to gather all the evidence you can that's favorable to you. But if it's not favorable and it's requested, you have to produce it. Unless, putting aside the privilege and exceptions, it has to be done. It's not our duty or our job to change the facts. It's our duty and our job to argue what these facts mean. It's our duty to explain how application of the law should lead to a remedy that's favorable to our clients. So argue and get creative all you want with the law and application of the law to the facts. Argue what these facts mean. Argue that this contract that you found that on its face doesn't seem favorable to your client. Argue why it's really not so bad. That's what lawyers do. They don't change the contract. They don't delete the contract. So if you're doing a document review late at night, you come across a document that is killer bad, it can be tempting just to click irrelevant instead of relevant. Who would know? You might get away with it. It might, make a difference between winning or losing. But you'll know, and you'll have to live with that. Unless you're a psychopath, it's going to be bad. If you are a psychopath, well, you won't be watching this essay anyway. And you don't worry about the other bad guys. They will be caught. They will be outed. Even though they might click it irrelevant and hope to get away with it, there's a lot of people out there that'll be looking for the same document. There may be copies they don't know about. And if they're caught, the judges will come down hard on them. Lawyers like me will come down hard on them. The few bad apples, we have to be dealt with accordingly. And that's why we're seeing the sanctions. The judges get this. Other attorneys get this. It's not a game, though. You just shouldn't throw sanctions around. It's just serious business. We're talking about honesty or not. We're talking about people that are they ethical or not. It's different than just making a mistake. Okay, everybody makes mistakes. You're not going to get sanctioned for a mistake. Not likely. You're going to have to show bad faith, proof, evidence of intent. Then you could and you should be sanctioned. So when you come across this document late at night, don't even think twice. Mark it relevant and start thinking about how you're going to explain it away. Hey, you don't have to produce it on the top of the pile. You don't have to immediately call opposing counsel and say, hey, you got to see this document. You were right, I was wrong. You're going to win. No. You got to produce it. You got to produce it in a timely manner. Who knows? I've been in that situation before, and the other side was so lazy they never even saw it. It wasn't a killer document, but it was pretty bad. Went to mediation, expected them to hammer me on it. I was prepared for it with the rebuttal and the yeah, but and explanation. You know what? They never even saw it. Well, don't count on that, though. That was just a rare thing. They're going to find it, and you'll be ready. You'll argue. It's rarely the end of the world, or if it is, make the best out of it that you can. But don't be tempted to hide the ball. Don't be tempted to cheat. You're liable to get caught. And if you're caught, you're liable to get sanctioned. Even if you aren't sanctioned, word spreads. Attorneys talk to other attorneys. They'll explain what a slime ball so-and-so is. The word will get around. Your reputation is the main thing you have as a lawyer. It's critical. You lose your reputation, you might as well change jobs, do something else, because in the law, trust, integrity, they're all important. People can't trust you. They don't think you have integrity. They won't make a deal with you. They won't ever take your things face value. So you need to trust opposing counsel until they show you to the contrary, but you also need to verify. Trust but verify, particularly if you don't know the attorney, if you don't know their reputation. And if they got a bad reputation, you got to verify the hell out of it. But believe me, you come in as a judge with this, it'll happen. I mean, you wouldn't believe the kind of things I've seen. I've seen attorneys try and take exhibits off of a trial table and hide them. So I know there's some bad folks out there. And if you catch them, don't hesitate to point them out. Maybe even turn them in. You have an ethical duty in most states to turn in counsel who is unethical. Because this is really critical stuff, doing the right thing, ethics. This is what makes law a profession and not just a business. This is the proud tradition of the law, where lawyers trust each other and they can make deals. This is the basis of discovery in our legal system, is trusting the attorney to do the right thing, trusting them to turn over evidence, even if it's harmful to their client. And if we lose that, we're liable to lose the entire system that we got. And maybe the Rules Committee someday will take away this voluntary discovery by attorneys. Maybe instead, judges will appoint masters that will do everything. I'm not in favor of that. And I believe in American lawyers. I believe in our system of justice, and I think it'll work. But listen, we all need to be reminded of this importance of justice, the importance of ethics to justice, and you sleep better if you do the right thing. You avoid the slippery slope. So don't think twice. Explain it to your client, not like there's a choice, but this is the way it works. That's your job, to explain to clients the way it works, to help them comply with the law, to follow the rules. That's your job, and you need to fully discharge it in an honorable fashion. That's what being a lawyer is all about.